On today's episode of Handmaid's Tale, we're hearing a Mississippi challenge to Roe v. Wade.
Mr. Chief Justice, and may it please the court, Roe v. Wade and Planned Parenthood v. Casey haunt our country.
With the court's new conservative justices, it was not a matter of if, but when they'd be hearing a challenge to Roe and Casey.
The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said, we're doing it because we have new justices on the Supreme Court.
The question is, how far will these 3 new justices go in stripping away abortion precedent?
What is your argument against applying the undue burden standard prior to viability? We're fighting the hypothetical here, counsel, all right? Accept the hypothetical.
And as Justice Sotomayor puts it,
will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
But if you ask me, stench would be an understatement.
Justice Sotomayor, I think the concern about appearing political makes it absolutely imperative that the court reach a decision well-grounded in the Constitution, in text, structure, history, and tradition, and that carefully goes through the stare decisis factors as we've laid out. No, it didn't, Your Honor, respectfully.
You know, it's not too often that a lawyer in front of the U.S. Supreme Court says, no, that's not true.
And without further ado, I'm John Ball.
And I'm David Ball.
Let's get into it. Hello and welcome to Two Balls, One Court, the Supreme Court Analysis Podcast. On today's episode, we're going to be talking about the case Dobbs v. Jackson Women's Health Organization, the Mississippi abortion ban case after 15 weeks. A very important case that a lot of people have their eye on, especially with 3 new justices, conservative justices on the court. People are very eager to see how they will affect women's right to an abortion moving forward. But first, we do have some very important updates. Dad, do you want to get us started off?
Yes. Our last podcast talked about the Biden vaccine mandate on large employers employing over 100 people. We did that on the weekend before it was going to go into effect on January 10th. The challengers to the abortion ban wanted the Supreme Court to issue an immediate stay because the regulation required large employers to do a number of things beginning on the next business day, Monday, January 10th. The court did not issue an immediate stay on that Friday, January 7th. They did not issue anything over the weekend. So I have employer clients who were anxious, but not knowing exactly what the outcome would be. But by the Thursday of the following week, so when the regulation had been in effect 4 days, the court did issue a stay. We had discussed last time whether I could foresee that happening, and of course, it's not a surprise from a political point of view that the court would have voted against the Biden administration's vaccine mandate, given that the court has a majority of Republicans on it. But stepping back from the political point of view, I did not think the court could find that it's in the public interest to stop a vaccine mandate that was intended to slow the raging spread of the Omicron variant.
Well, and just to jump in real quick, too, because something I found interesting was those oral arguments happened when, I think during the peak of Delta, or Delta had calmed down a bit.
Delta had calmed down.
Delta had calmed down, and then when they were writing the opinion, it was at the surge of Omicron, so the numbers that were coming in were significantly worse than they were during the oral arguments. And so I was very curious how that would affect the opinions, but it didn't quite seem to.
No, it didn't seem to in the end for the majority. The sixth justice of the sixth justice majority, in a sense, dodged, I think, based on a long line of prior case law, the court dodged a mandatory issue that is required under many, many cases, that it balance the harms that issuing the stay would have caused. That's a mandatory finding in order to issue any kind of an injunction or a stay. And the court explicitly said, we know that there are competing harms. There is possible disruption of the economy if the mandatory stay is kept in place, and there is the possibility that the spread of the virus won't be checked by the vaccine mandate if we don't issue the stay. And they dodged the question. They said, well, we see harms on one side, harm on the other side. We're supposed to decide what's in the public interest. Well, we're not going to do that. That's for Congress to decide, the majority said. The dissent, which was Breyer, Kagan, and Sotomayor, took them to task for this. It really is a requirement for a court to issue any kind of an injunction, stay, that they find that it's in the public interest to do that. The court dodged the question and said it wasn't going to make that finding. It was going to punt that issue over to Congress. So the vaccine mandate has been stayed. Technically, the Supreme Court kicked the issue back to the Sixth Circuit Court of Appeals for further proceedings of the cases that are very early on, but it's hard to imagine that the Sixth Circuit could do anything other than go down the line of the U.S. Supreme Court, which said, in terms of the result and the rationale, that OSHA does not have the authority to do something that drastic based on its power to ensure that Americans have safe workplaces to go to.
But they did uphold the vaccine mandate for healthcare professionals.
In certain settings, only in more traditional hospitals, long-term care facilities that are Medicaid and Medicare certified. So it's by no means all healthcare employees in the U.S.
Well, on the theme of punting things over to Congress and sort of stripping away prior legal precedent, not to get too ahead of ourselves here, but anything you want to say before we get started with some of the audio for Dobbs v. Jackson Women's Health?
Well, what I'd like to say at the beginning is that, frankly, I found the opening argument of the attorney for the state of Mississippi seeking to uphold the Mississippi restriction shocking. He makes several points about why this needs to be overturned that are completely at odds with everything that you and I have ever learned about the purpose of the Constitution.
Well, let's get into it.
We will hear argument this morning in Case 19-1392, Dobbs versus Jackson Women's Health Organization. General Stewart.
Mr. Chief Justice, and may it please the Court, Roe v. Wade and Planned Parenthood v. Casey haunt our country. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they've kept this court at the center of a political battle that it can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a right to end a human life. Consider this case. The Mississippi law here prohibits abortions after 15 weeks. The law includes robust exceptions for a woman's life and health. It leaves months to obtain an abortion. Yet the courts below struck the law down. It didn't matter that the law applies when an unborn child is undeniably human, when risks to women surge, and when the common abortion procedure is brutal. The lower courts held that because the law prohibits abortions before viability, it is unconstitutional no matter what. Roe and Casey's core holding, according to those courts, is that the people can protect an unborn girl's life when she just barely can survive outside the womb, but not any earlier when she needs a little more help. That is the world under Roe and Casey.
So he's essentially summarizing his view.
Sorry to interrupt you, Dad. I do have his oral argument. His opening statement goes on a little bit more here.
And I was honored to be called upon by God to help make that dream come true for generations to come. And while I may have been thwarted in my
sorry.
efforts,
My child is missing!
This is a trailer of Handmaid's Tale for season 3. I don't know how this got slotted into his opening statement. Sorry about that.
Gilead.
But Anyway, sorry.
I love Handmaid's Tale.
Well, yeah. Well, this is a very interesting episode here. Before the Supreme Court, I can't wait to see the season finale. Actually, I can. But anyway, please.
That was
continue.
great, Sean. I loved it. You've done the same thing I was going to do in a different way, which was say, we're about to hear the really scary stuff. So here we go.
Okay.
That is not the world the Constitution promises. The Constitution places its trust in the people.
Whoa. No. The individual rights embodied in the Constitution, and they're essentially in the Bill of Rights and then the 14th Amendment, does not place the trust in the people. The Bill of Rights and the 14th Amendment assumes that the majority might engage in tyrannical legislation undermining the rights of the minority. So we need the Constitution to protect the people from the tyranny of the majority. Flat out wrong when it comes to U.S. political, governmental policy and theory.
On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone, and when the Constitution does not take sides on it, it belongs to the people.
So his key move there is saying the Constitution doesn't take sides on it, so it belongs to the people. Kind of a, not very surprising, not very original point of view that, the Constitution says nothing about the right of privacy.
Mm-hmm. And, here too, I can definitely see the argument being sort of normatively appealing, of saying, this issue is so controversial, we ought to let the voters decide, because it's sort of a normative judgment that people make in their own lives. And I think it's something that could really appeal to the justices who are sort of eager, obviously, to overturn Roe, and we'll see this some more later, but what do you make of that argument that, this is controversial, so the court shouldn't be deciding it? The court shouldn't be deciding who has this individual right. States should decide for themselves who has this right.
Well, I'm reminded of something that I was just teaching in the law school class I teach. James Madison wrote a very famous treatise called The Memorial and Remonstrance, when the issue before the Virginia legislature was, should they pass a tax to fund paying salaries of ministers in order to make sure that there were plenty of Christian ministers around, on the belief that it was important to promote Christian values for the sake of our democracy. And Madison said, hey, that's pretty controversial. In fact, it's so controversial, I don't think it should be something for the majority to decide. We shouldn't have a decision of that kind unless it's virtually everyone who's united on the issue. Mm-hmm. So either, my view is, you've got protections in two ways when it comes to controversial issues. You've got the Bill of Rights, which says the majority doesn't get to decide. And then I'm remembering James Madison, who says, if you want to talk about a controversy, that should be a decision of just about everybody.
Right. And going into discussion on this, so the case law that gets brought up a lot is Roe v. Wade and Casey. So I'm going to play a clip here that I think tees up discussion on those two cases. And why don't we have you translate for the rest of us what those two cases mean moving into our current discussion on Dobbs v. Jackson Women's Health.
Roe and Casey have failed, but the people, if given the chance, will succeed. This court should overrule Roe and Casey and uphold the state's law. I welcome the court's questions.
General Stewart, you focus on the right to abortion, but our jurisprudence seems to focus on, in Casey, autonomy, in Roe, privacy. Does it make a difference that we focus on privacy or autonomy, or more specifically on abortion?
So, as I asked you a little bit before, if you could translate those cases, what are the stakes of Justice Thomas's question here? And what did those two cases set up as precedent for abortion prohibitions or regulations?
So the stakes of what he's asking is it clear that the Constitution really does protect this right? And he's asking about the right to privacy, and there's long been argument that the right to privacy doesn't actually exist in the Constitution. And he's asking about the right to autonomy or the right to choose. And again, the argument from the folks who are seeking to overturn Roe and Casey is that you can't point to anywhere in the Constitution where it says individuals have that right. Now today, he's asking about a third type of right, the right to an abortion, and he's asking the attorney who's defending the Mississippi law to clarify which of those we're really talking about. I think what he's essentially doing is trying to pin down the discussion as to which right or rights are at stake, and then his next move would be to say, but none of those are in the Constitution.
Now, one thing specifically in those cases I want to ask you about, and it comes up more and more in the arguments. So Roe set up this viability line standard, and in Casey it set up the undue burden standard. Could you translate, into plain English what those mean moving forward in these oral arguments?
Well, first, it was Casey who did both the viability standard and the undue burden standard. So yeah, let me spell that out. So Roe said, we're going to look at this 9-month pregnancy in trimesters.
Right.
For the first 3 months, the government, the state, has no right to regulate. In the second 3 months, the state can regulate, but only for a limited purpose, for the sake of the woman's health. And in the final 3 months, the state has more freedom to protect the soon-to-be-born, if you will, life that is to come. So Casey comes along and says, you know what, that trimester framework, the first trimester is over at 26 weeks. We're not sure that's the right line to draw. We want to draw the viability line, which they said was about 24 weeks, given the current state of medical science. So it was actually a drastic curtailment of protections for women's right to choose, because it said after 24 weeks, the states have a fair amount of flexibility to enact regulations, whereas Roe said it was only after 6 months. So that second trimester of protection is essentially lost with Casey. And even during those first 24 weeks, prior to viability, Casey said states have the right to regulate so long as it does not create an undue burden on someone's ability to get an abortion. So Casey is this combination of viability line at 24 weeks and prohibiting undue burdens prior to 24 weeks.
And to sort of give some examples of the undue burden standard and what that means, we in politics, I think these get called trap laws a lot, but supposedly the undue burden standard, well, some states can still require psychological examinations of women getting an abortion to determine whether they're quote unquote psychologically fit to make this decision for themselves, or states can require things of the abortion clinics that aren't necessarily related to health standards, but we would argue probably are just trying to give abortion clinics a difficult time, mandating the size of hallways or number of rooms in the clinic. Is that correct in sort of understanding examples of these laws that may or may not pose undue burdens?
Right. Opponents of abortion have been racking their brains to think of things that they could enact into law that would be an undue burden because they want to stop abortions, but that the courts might not say were undue burdens. So they're thinking up things. They're just investing a tremendous amount of creativity, I would say, thinking things up that they think will slow things down. But they're hoping then that they'll be able to enforce them if the courts won't view them as undue burdens.
All right, so we've talked a bit about the previous cases, and I think you have a clip here from Justice Breyer that's going to help give some more context.
I'd like to go to a different topic, back to Casey.
Yes,
I assume you've read Casey pretty thoroughly.
Yes, Your Honor.
And there are two parts. One is they reaffirm Roe. Put that to the side. The second is an opinion for the court, not for three people.
Sorry to stop it. I think Justice Breyer sounds pretty weary here.
He did announce his retirement today, but I have to say, in the cases we've covered so far on the podcast, he's been at the top of his game, and we're going to see some of that now.
Right.
But for the court. And that second part is about what stare decisis principles should be used to overrule a case like Roe. And they say Roe's special. What's special about it? They say it's rare. They call it a watershed. Why? Because the country is divided, because feelings run high, and yet the country, for better or for worse, decided to resolve their differences by this court laying down a constitutional principle, in this case, women's choice. That's what makes it rare. That's not what I'm asking about. I want your reaction to what they said follows from that. What the court said follows from that is that it should be more unwilling to overrule a prior case. Far more unwilling we should be, whether that case is right or wrong, than the ordinary case. And why? Well, they have a lot of words there, but I'll give you about 10 or 20. There will be inevitable efforts to overturn it. Of course there will. Feelings run high. And it is particularly important to show what we do in overturning a case is grounded in principle and not social pressure, not political pressure.
Very interesting thinking there. The argument of those seeking to uphold the law is that there's all of this feeling in the country, all of this objection to Roe, all of these legislatures creating laws that would require Roe to be overturned. And so the argument is, look at all this political pressure. Certainly that points in the direction of Roe being overturned. And what Justice Breyer is arguing is, when you've got a watershed precedent, when the court enacts a watershed precedent, they do that precisely because they know there will be efforts to overturn it in the legislatures. And so watersheds need to be those cases that are untouchable. Why? Because everyone knows when they're decided, there will be groundswell efforts in state legislatures to try to undermine those cases.
Right, and just to summarize a little bit more, so the court should be suspicious or maybe even have a higher standard for overturning these cases, despite there being large swells of pressure, because, well, it's, maybe unrelated to the law or could undermine their ruling. Is that a correct understanding?
That's correct, and it's in harmony with the fundamental purpose of the individual rights in the Constitution, which is, as the founders were well aware, there will be times when a majority turns on certain types of individuals, and we need constitutional protection so that any laws that do that are unconstitutional and won't be enforced.
Right. I'm going to play a little bit more of this quote, and then I have something to ask you.
Only, quote, the most convincing justification can show that a later decision overruling, if that's what we did, was anything but a surrender to political pressures or new members. And that is an unjustified repudiation of principles on which the court stakes its authority. And then there are two sentences I'd like to read, because they say they really mean this, the court, not just three. To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. And the last sentence, after they quote Potter Stewart on the same point, they say overruling unnecessarily and under pressure would lead to condemnation, the court's loss of confidence in the judiciary, the ability of the court to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. Now, that's the opinion of the court. All right? And it's about stare decisis and how we approach it. And I hope everybody reads this. It's at 505 U.S. 854 to 869.
So I included that last part. You know that feeling when you're in the group project and, you just want the other people to read the assignment so bad, but some people, there's just absolutely no way that they're ever going to read what they're supposed. I think that might have influenced Justice Breyer retiring after this case, but that's neither here nor there. So what I want to ask you about, so Justice Breyer had some very powerful quotes there about, if the court surrenders to political pressure here, that would lead to, quote, condemnation, the court's loss of confidence in the public's loss of confidence in the judiciary, and the ability of the court to exercise their judicial power. So here he talks about legitimacy, and that I take it to mean being, if a ruling's seen as political, that very strongly undermines the court's legitimacy. And one thing I find really interesting here is, I think it's interesting that the justices think that there is any legitimacy left of the court to save. I'm going to be, I'm biased here, but I don't know anyone walking down the street who is informed of the court or generally aware of previous cases, who's thinking like, man, I'm just feeling so chill right now about whether Merrick Garland or Brett Kavanaugh get appointed to the Supreme Court. In almost every political discussion, whenever someone who's loyal to a party is saying, I'm not sure about whether I want to vote for our candidate, there's always the argument of, there could be Supreme Court justices retiring, and that is just as, if not more important for, the lifelong precedent that will be in line with your political values, such as, reproductive rights. And that's why, when Ruth Bader Ginsburg was getting old, I mailed several of my internal organs to her address. I don't know if she used them. I hope she did. She unfortunately passed away during Donald Trump's term. And, Donald Trump and company appointed a conservative woman, a member of the Federalist Society, to take her place. And I think it is indisputable the difference made by no longer having Ruth Bader Ginsburg on the court, especially on this case of all cases. So I said a lot there, but legitimacy and politics, what do you think about all that?
There are surprises from the court, and I think that is the sort of counter argument. Yes, clearly, the party in power in the presidency and with control of the Senate seeks to appoint justices, certainly in the last decade or so, justices that will promote the priorities of that party. And it certainly came to a head in the past few years with Merrick Garland's nomination being blocked during the latter part of the Obama administration. That said, the parties do not always get what they were hoping for from the justices who get
Yep.
appointed. And one great example of that is that President Richard Nixon appointed Justice Blackmun, a Republican, who was the author of Roe v. Wade. So I think...
And one big example, too, Justice Sandra Day O'Connor.
Justice Sandra Day O'Connor wrote the plurality opinion in Casey. Is that the one you're referring to? Upholding Roe, which was a big surprise and a big disappointment to those who had been so supportive of her appointment, because they believed once she got on the court, she would be the deciding vote. So something happens, I think, to justices and the way they look at the world. Once they've been appointed, maybe they were appointed as the part of a very partisan process, but I do think they lift above that when they get on the court. Some.
Right. There's
and sometimes.
Right. There's some people who we're still waiting on them to lift above that whole thing. Hopefully that'll kick in soon, you know?
Yes, hopefully.
Right. And, you know, I was saying before, hopefully they're not up there thinking like, oh yeah, all this is anonymous, right? All these things I'm writing. No one knows. No one's going to put my name with. My grandkids aren't going to have to see this, right? But so hopefully they're well aware of, you know, how often people read their opinions. But
so one of the most impressive lines of questioning we had in this oral argument was that of Justice Sotomayor. I would call it a tour de force, very, very powerful, making of several points, challenging the legitimacy of this law.
Conclusions were, with respect, Justice Breyer, mistaken. And the last 30 years has not seen any calming of that. It's been very different than some of the court's other controversial decisions that have seen much more calm.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged.
Point number one in Justice Sotomayor's tour de force, all of this talk about how the courts have been topsy-turvy and inconsistent and all these things have been changing, not so much. Casey's been there and hasn't changed.
So you don't think she's impressed by Fred from Handmaid's Tale yet?
I don't think so, but maybe she hasn't watched it.
Okay, got it.
On we go.
You want us to reject that line of viability and adopt something different. 15 justices over...
I'm sorry, I said Fred from Handmaid's Tale. He'd probably be offended. It's Commander Waterford in these public situations.
Yeah, show some respect.
Right. Sorry. Okay.
50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds.
Point number 2, sort of in response to what we were talking about before, isn't the court politicized? In 30 years since Casey, if you count it up, 15 justices have reaffirmed Casey, 4 have opposed it, and 2 of them are members of the current court. 15-4, pretty strong support for Casey, not a demonstration of politicization of the issue.
Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
Will this institution survive the stench?
Yeah.
How brazen, she's saying, of these legislators in Mississippi to say, hey, we've got new justices, let's try again.
Right, they're saying it out loud, and I mean, it's interesting to me. You would think they would try and not literally say that, at risk of offending the justices, since they do care.
Exactly. It's surprising.
But we'll see if that offends enough of them for them to really care.
We will find out.
I don't see how it is possible. It's what Casey talked about when it talked about watershed decisions. Some of them, Brown versus Board of Education, it mentioned, and this one, have such an entrenched set of expectations in our society that this is what the court decided, this is what we will follow, that we won't be able to survive if people believe that everything, including New York versus Sullivan, I could name any other set of rights, including the Second Amendment, by the way. There are many political people who believe the court erred in seeing this as a personal right as opposed to a militia right. If people actually believe that it's all political, how will we survive? How will the court survive?
A deft little parry there by Justice Sotomayor saying, if it's all political, folks, do you realize that could mean the Second Amendment protections that you are so invested in on the conservative side, they could be voted away too, if we really do politicize the court to that extent.
Right.
Justice Sotomayor, I think the concern about appearing political makes it absolutely imperative that the court reach a decision well-grounded in the Constitution, in text, structure, history, and tradition, and that carefully goes through the stare decisis factors that we've laid out. No, it didn't, Your Honor,
Casey went through every one of them. You think it did it wrong. That's your belief. But Casey did that.
It's not too often that a lawyer in front of the U.S. Supreme Court says, no, you're wrong. That's not true. Yeah, that's essentially what just happened. The attorney for Mississippi, Attorney General Stewart, no, it didn't, Your Honor. And then he added the word respectfully.
Right. Thank you for translating the legal speak into things that we can understand. That's why we're doing this.
That was fun.
Well, and you haven't added much to the discussion in your papers as to the errors that Casey made, other than I disagree with them, Casey.
Wow.
Long pause.
Justice Sotomayor, maybe I can highlight two. Casey gave one paragraph to the workability of Roe. It then adopted the undue burden standard, which is perhaps the most unworkable standard in American law. It gave about 3 paragraphs, if memory serves, to reliance, which doesn't account for the last 30 years and the changes that have occurred since Casey. It gave a brief factual view to things that have changed since Roe. Those, of course, are not going to take account of the last 30 years of advancements in medicine, science, all of those things.
What are the advancements in medicine?
I think it's an advancement in knowledge and concern about such things as fetal pain, what we know the child is doing and looks like and is fully human from a very early...
In regular cases, courts decide whether science fits the Daubert standard.
Okay, quick primer on the Daubert standard. Under federal law, procedural law, courts should not admit into evidence scientific things that are not pretty well established in that scientific community as being, solid. Now, there's a lot of nuance to that, but I did want to explain what she meant by the Daubert standard, and then she'll talk about how what Attorney General Stewart claims is advancement in science isn't really widely held.
Obviously, under the Daubert standard, the minority of people, a gross minority of doctors, who believe fetal pain exists before 24, 25 weeks. It's a huge minority, and one not well-founded in science at all.
Ouch. A gross minority. You know, I didn't know that. I haven't fact-checked this, but if she's right, that it's a gross minority of doctors that believe that there is a phenomenon of fetal pain prior to 24 weeks, that's disturbing, because that's the whole premise of the Mississippi law.
Well, I'm starting to hear that you are questioning Commander Waterford's knowledge of the science.
You know, I think he might have watched The Handmaid's Tale and gotten things mixed up.
Yeah, mixed up. It's supposed to be bad, right? But anyway, that's you know, that's the whole beauty is in the eye of whomever. You know, it's like, okay, do you see this as a utopia or a dystopia? Anyway, I digress.
So, I don't see how that really adds anything to the discussion. That a small fringe of doctors believe that pain could be experienced before a cortex is formed doesn't mean that there's been that much of a difference since Casey.
We pointed out as an example, Your Honor, of where Roe and Casey improperly preclude states from taking account for these things, and they should be able to be concerned about a fact of an unborn life being poked and then recoiling in the way one of us would recoil.
General, I know what it said about viability in Roe, but
Chief
was
Justice
viability an issue in the case? I know it wasn't briefed or argued.
It was not an issue certainly the way it is an issue here, Your Honor. I think it was, to the extent that the court had to reaffirm Roe. The way to read that as something other than dicta would be to understand.
I'm sorry, I don't know what that said. Was it an issue in Roe?
Oh, in Roe?
Yeah.
I'm sorry, Your Honor. My understanding is no. I mean, the law there was didn't have a viability tag. That was inserted by.
In fact, if I remember correctly, and it's an unfortunate source, but it's there. In his papers, Justice Blackmun said that the viability line was dicta, and presumably he had some insight on the question.
I think, and I'd add, Your Honor, Justice Blackmun, in I think as well his papers pointed out the arbitrary nature of it and the line drawing problems in there too.
And then in Casey said that was the core principle or the central principle in Roe, viability. It said that after tossing out the trimester formula, which many people thought was the core principle. But was viability at issue in Casey?
I don't think it was squarely at issue, Your Honor. Again, it's a little hard not to take the court at its word when it emphasized that viability is the central part of Roe's holding, and saying that it is reaffirming that. So we kind of take that as it stands, but the court has not. It did not face a law like this, certainly, Mr. Chief Justice.
May I finish my inquiry?
Back to Justice Sotomayor.
Virtually every state defines a brain death as death. Yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response by a fetus necessarily proves that there's a sensation of pain or that there's consciousness. So I go back to my question of what has changed in science to show that the viability line is not a real line, that a fetus cannot survive. And I think that's what both courts below said, that you had no experts say that there is any viability before 23 to 24 months.
And what I'd say is this, Justice Sotomayor, is that the fundamental problem with viability, it's not really something that rests on science so much. It's that viability is not tethered to anything in the Constitution, in history, or tradition. It's a quintessentially legislative line. A legislature could think that viability makes sense as a place to draw the line, but it's quite reasonable for a legislature to draw the line elsewhere.
There's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison.
Okay, now we're talking about some strong moves here. For everyone's sake, the fact that the Supreme Court gets the final say on what is and is not constitutional, I hope you're all sitting down. It's not in the Constitution. Well, should we just close up the Supreme Court and not have one because it's not in the text of the Constitution? I think we're well past that point. And so she's going to talk about how the court has seen in the structure of the Constitution that role, as well as the rights at issue in this case.
There is not anything in the Constitution that says that the Supreme Court, is the last word on what the Constitution means. It was totally novel at that time. And yet, what the court did was reason from the structure of the Constitution that that's what was intended. And here in Casey and in Roe, the court said there is inherent in our structure that there are certain personal decisions that belong to individuals and the states can't intrude on them. We've recognized them in terms of the religion parents will teach their children. We've recognized it in their ability to educate at home if they choose. They just have to educate them. We have recognized that sense of privacy in people's choices about whether to use contraception or not. We've recognized it in their right to choose who they're going to marry. I fear none of those things are written in the Constitution. They have all, like Marbury versus Madison, been discerned from the structure of the Constitution. Why do we now say that somehow Roe and Casey are so unusual that they must be overturned?
Well, Justice Sotomayor, I would emphasize two things. When you're going beyond the Constitution, this court has looked closely to...
No, what I'm saying is they didn't go beyond the Constitution.
So you called it a tour de force earlier. Do you want to help unpack some of the last content or keep score? A while ago, we were keeping track of how many points she made. Recently, I thought it was very interesting too, just kind of recapping or doing a play-by-play. I mean, in her question, she said, so I return to my previous inquiry, what has changed in the science after her point about, fetal pain not necessarily being relevant at all, even granting the hypothetical that, what if more doctors believed it were a thing. And then he just sort of pivoted to say, well, the legislature should decide this.
Yes. The best way to sum it up, I think, is to say that she took the strongest arguments of those who want to see Roe and Casey overturned, and I think to anyone with an open mind, demolished them.
Right. So the Commander Waterford was making points about, how Casey and Roe, in his eyes, were so disgusting that they have to be overturned. This is another case in the ranks of, just like how Brown v. Board of Education overturned Plessy v. Ferguson, we've got to do that here. And I think later on in the oral arguments, we have something lined up kind of explaining why that doesn't quite make sense.
that is a key distinction with the list of precedents that Justice Kavanaugh was relying on. I think that there are really two key distinctions. And the first is that in the vast majority of those cases, the court was actually taking the issue away from the people and saying that it had been wrong before not to recognize a right. And I think that matters because it goes straight to reliance interests. Here, the court would be doing the opposite. It would be telling the women of America that it was wrong, that actually the ability to control their bodies and perhaps the most important decision they can make about whether to bring a child into this world is not part of their protected liberty. And I think that that would come at tremendous cost to the reliance that women have placed on this right and on societal reliance and what this right has meant for further ensuring
reliance
equality.
Point is it?
That I thought was very powerful.
That was Solicitor General, U.S. Solicitor General Prelogger, making a point, sort of very big picture. Yes, there have been times when the court has overturned very significant cases. But each time that happened, it was because in the previous cases, the court had overlooked an important individual right. Those cases, overlooking an important individual right, need to be overturned. This one is a case that recognizes an important individual right, not the kind we overturn.
Right. It's the kind of case where I loved her phrasing that it would say, oh, it was a mistake to recognize women's rights here. You know, it was a mistake to have 50 years of allowing, you know, right to privacy, right to an abortion, right to liberty. And I thought, you know, that language there about, I mean, taking away what individual rights have already been protected for 50 years. I mean, that was very powerful, I thought.
Yes, I agree. And again, it's in line with the fundamental purpose of the Bill of Rights, which is to protect people against legislatures enacting laws that trample on individual rights. John, I actually have a pet peeve when it comes to Supreme Court decisions, and I want to play a clip that reflects that. My pet peeve is sometimes the court makes decisions that are completely disconnected from the concrete reality of people's lives. And that just bothers me. There are times when the court will say things that completely ignore the impact that their decisions will have. Here we have Ms. Reichelman, who's an attorney for the challengers to the Mississippi law, raising that concern in a powerful way.
Your Honor, I believe they would, because people who need abortion after 15 weeks are often in the most challenging circumstances. As I mentioned, there are people who have perhaps had a major health or life change, a family illness, a job loss, a separation, young people or people who are on contraception or pregnant for the first time and who are delayed in recognizing the signs of pregnancy, or poor women who often have much more trouble navigating access to care. And if they're denied the ability to make this decision because there's a ban after 15 weeks, they will suffer all of the consequences that the court has talked about in the past. And in fact, the data has been very clear over the last 50 years that abortion has been critical to women's equal participation in society. It's been critical to their health, to their lives, their ability to pursue.
I'm sorry, what kind of data is that?
I would refer the court to the brief of The Economist in this case, Your Honor, and it compiles data showing studies based actually on causal inference, showing that it's the legalization of abortion and not other changes that have had these benefits for women in society. And again, those benefits are clear for education, for the ability to pursue a profession, for the ability to have...
Well, putting that data aside...
Well, why are we putting that data aside?
Because we don't like it.
Oh, because we don't like it, yeah. Sometimes the data doesn't mesh with the way we want things to go when we're on the Supreme Court, and that's my pet peeve. I think the Supreme Court should be more responsive to fact-based information about the impact that their decisions will have. Here we have that information from a brief written by economists about the benefits to women that the right to choose has established for their lives. And Chief Justice Roberts says, well, let's just put that to the side.
And also, expanding a little more on the topic, I mean, my sister, it would have been a little crowded to fit her in the studio for 3 balls, 1 court. But, she's studying to be a nurse, and she has seen a lot of pregnant women who, it's a lot more common than people would think, especially than probably chief justices of the Supreme Court would think. It's a lot more common for women to not be aware that they're pregnant for a while than most people would assume. And as one can imagine, the people who are not aware that they're pregnant until much later have more often than not, are more likely to seek an abortion. And so that's something that, when the justice says, well, putting that data aside, I mean, it's just one of those, I think, heartbreaking examples of, just how many degrees of separation there are between the court and regular people. I don't know if you agree.
Well, all of this by Ms. Reichelman, yes, John, all of this by Ms. Reichelman is in response to the Chief Justice saying, why isn't 15 weeks enough? And the answer to that is because many times people don't know for 15 or more weeks, or until 14 or 13. I, as a 61-year-old father, I assumed until we got to talking to your sister that any woman would have to know by, about 5 weeks, right? Because the menstrual cycle is about 4 weeks. Not the case, according to the facts.
Right.
You have
Next, we have some material on what is probably the thing that most people are interested in when listening to this episode. So we've done a lot of coverage on the law so far, but unfortunately, as is the case in many political cases like this one, as I would argue, not just the law, you got to think about the characters on the court, the new characters. So there's 3 justices. There's Justice Barrett, Justice Gorsuch, and Justice Kavanaugh. And what we have up here is some lines of questioning. As we've talked about before, you can sometimes get an idea for how a judge will rule based on their questions. As they're sort of announcing to the other justices what their legal inquiries or relevant frameworks are. So I'm going to play here exchange starting with Justice Barrett that I think says a lot about how she might rule.
Ms. Rickelman, I have a question about the safe haven laws. So petitioner points out that in all 50 states, you can terminate parental rights by relinquishing a child after abortion, and I think the shortest period might have been 48 hours, if I'm remembering the data correctly.
So, real quick, do you want to translate for us what safe haven laws means here?
Yes. Safe haven laws are laws that permit someone who's had a child and they're not prepared to raise it. They can drop it off. I believe it's fire stations, police stations, I'm not positive on that, and not be charged with a crime for abandoning a child. Now, Justice Barrett misspoke there. She was talking about relinquishing a child after abortion. I think she had to mean relinquishing a child after birth.
Yeah.
So it seems to me, seen in that light, both Roe and Casey emphasized the burdens of parenting. And insofar as you and many of your amici focus on the ways in which the forced parenting, forced motherhood would hinder women's access to the workplace and to equal opportunities. It's also focused on the consequences of parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of that problem? It seems to me that it focuses the burden much more narrowly. There is, without question, an infringement on bodily autonomy, which we have in other contexts like vaccines. However, it doesn't seem to me to follow that pregnancy and then parenthood are all part of the same burden. And so seems to me that the choice more focused would be between, say, the ability to get an abortion at 23 weeks or the state requiring the woman to go 15, 16 weeks more and then terminate parental rights at the conclusion. Why didn't you address the safe haven laws, and why don't they matter?
So the fact that women can give up their children for adoption, that could be Justice Barrett's angle for why, she doesn't perceive it to be that big a deal to get rid of a right to an abortion. What do you think about her question?
I think she's going down the line of, it's not an undue burden if we do dial back to 15 weeks because the women always have that option of the safe haven laws. Next we have Justice Gorsuch, and he's going to take on the powerful arguments that have been made by Justice Breyer and Justice Sotomayor about the importance of stare decisis, that when you have a watershed case, it shouldn't be overturned except in the most extraordinary circumstances. So let's see how he goes at that.
May I ask you a question about stare decisis, counsel? Your colleagues on the other side have emphasized that Casey rejected Roe's trimester framework and replaced it with an undue burden standard. They argue that the undue burden standard was...
For the viewers at home, Dave Ball here is twisting his mustache to reenact how Justice Gorsuch most likely is asking this question in the court. Sorry.
Not well known to the law before that. And then they argue that the undue burden standard has evolved over time, too, in ways that the court has found difficult to agree upon. In Hellerstedt, for example, they point out in their briefs that the court seemed to suggest that a court should consider both the benefits and the burdens associated with the proposed restriction. In June Medical, more recently, the court splintered on that same question, whether benefits could be considered or only burdens. And so the argument goes that this has proved to be, putting aside all the other obviously difficult questions in the case, that the standard itself has proved difficult to administer and that is relevant to the stare decisis analysis. And I just wanted to give you an opportunity to respond.
Yes, Your Honor. The first point I'd like to make is the undue burden test is not at issue in this case. That is the test that applies to regulations, not prohibitions, and the state has conceded that this is a prohibition. In fact, that's the title of this law, is an act to prohibit abortion after 15 weeks.
Wow. Okay, Justice Gorsuch, you're attacking the undue burden standard as a reason to overturn Roe and Casey, but Roe and Casey say that standard doesn't even apply to laws that prohibit abortions. Solid first response.
Oh, very impressed at how quickly that response came out too.
So here we go with some more.
And the only thing that's at issue in this case is the viability line, and the viability line has been enduringly workable. The lower federal courts have applied it consistently and uniformly for 50 years, and the Fifth Circuit here below had no difficulty striking down this law unanimously 3-0. So it's been an exceedingly workable standard. And if I may return to your question, Mr. Chief Justice, a reasonable possibility standard would not be workable. It would ultimately boil down to an argument that states can prohibit a category of women from exercising a constitutional right merely because of the number of people in the category, and that's just not how constitutional rights work.
Have I said that it's just not how constitutional rights work, that if the majority thinks that right shouldn't exist, then it doesn't exist?
You might have said it once. I forget.
All right. Okay. Here we go.
A state would never say that it could ban religious services on a Wednesday evening, for example, simply because most people could attend religious services on another night of the week.
So I actually just wanted to, that's helpful, I think. I just want to make sure I understand what you're telling me, counsel, that if the court were to, in this case, step past viability and apply undue burden, the undue burden test to regulations prior to viability, you would agree with the other side, I think, that that's not a workable standard. Is that a fair understanding what you're telling the court?
She's not saying that in a million years. She is defending Roe and Casey and the undue burden standard.
And she just said, well, respectfully, Your Honor, that's not even relevant to this case. But he just said, so let's see what she thinks of that summary.
No, Your Honor. I
You
believe
think that would be workable?
I believe that, if I may clarify, I believe the undue burden test has been workable for regulations.
I understand that. If it were to apply, if the court were to, and I thought this is what you were saying in response to the Chief Justice, but maybe I'm mistaken. Please correct me if I am. But what is your argument against applying the undue burden standard prior to viability?
If the undue burden standard, as this court laid out in Casey, which includes the viability line, is applied.
I'm asking. I know we're fighting the hypothetical here, counsel. All right, accept the hypothetical. Hypothetically, the court were to extend the undue burden standard to regulations prior to viability. Would that be workable, or would that not be workable in your view?
Without viability, it would not be workable, Your Honor, because.
So in that exchange with Justice Gorsuch, so he seems very keen. We've said this already. It's not relevant in this case, but he seems very determined to overturn the undue burden standard. I mean, he's saying, accepting what Commander Waterford said in his opening statement, that, it's the most unworkable standard on the planet or something like that. So what do you think that means for his ruling on this case?
Yeah, I think his ruling on this case is likely to emphasize that point, that what Casey came up with is vague, doesn't have any content. Courts don't know how to apply it. It's a complete mess. We got to get rid of it.
And do you think he'll care about the government's argument that that's not even at issue in this case?
I think what he's doing is saying it has to be at issue.
Right. By saying, what standard will there be once we get rid of the viability line?
That's where he's going.
Yeah, that's sort of the chilling part that I didn't pick up on until, rereading.
That's what it looks like.
All right, and last of the 3 new justices we have on the court for this case, we have Justice Kavanaugh.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion, and they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. But because they say the Constitution doesn't give us the authority, we should leave it to the states, and we should be scrupulously neutral on the question. And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue rather than continuing to pick sides on that issue. So I think
that really says a lot about Justice Kavanaugh's logic here. I mean, and we talked about this a little bit before, but I mean, they're just saying, the conservatives are saying, well, it's so controversial, we got to send it back to the states. Do you think Kavanaugh, that might be his opinion?
Controversial, and on the other side of that, nothing clear-cut in the Constitution. Mm-hmm. And so his point of view is, and many conservative arguments are made like this, in the absence of something explicit in the Constitution, then it's a political question for the states. I notice he's using one of his favorite words, which is neutrality. he uses that concept in the context of the court cases dealing with the religion clauses of the First Amendment, the Establishment Clause and the Free Exercise Clause. And it's interesting because that word has been used off and on by the court and by scholars over the years, but it's a word that can be used in different ways. And so what one person thinks is neutral might appear quite, hostile to individual rights in this instance. And so for his argument to work, for his version of neutrality to work, you would have to agree with him that the Constitution is neutral when it comes to the right to choose at issue here. And it is, if you're someone who says, I gotta see it right there in the words of the Constitution. But if that's your point of view, then the Supreme Court has no power at all, because that's not in the Constitution.
So stepping back from the theory here and talking, circling back to what we said about the three new justices. So we know how the three Republicans who are not new justices on the court are going to rule in this case. Probably high odds that at least two of them are going to say uphold Mississippi's ban and challenge to the viability line standard. These new justices, just to recap, so Justice Barrett saying, well, because there's safe haven laws, that means there's not that much of a burden associated with motherhood. Justice Gorsuch's questions about, accept my hypothetical about how terrible the undue burden standard is and how, therefore, we have to get rid of the viability line. And lastly, Justice Kavanaugh's statements about, oh, well, it's just so controversial, the Supreme Court just has to step back, which, by the way, sorry, I'm trailing off a little bit more. I would be shocked if, let's say if Roe v. Wade instead had been a anti-choice decision, I would be shocked if Justice Kavanaugh were saying, oh, it's so controversial, we ought to kick this issue to the states to let them vote on whether or not women can get abortions. But anyway, so circling back, the three justices, in our eyes, it looks like they're going to uphold this Mississippi abortion ban. I did write down a quote from Justice Roberts that we didn't play, but it was after Justice Breyer's comments about stare decisis. He said, I just want to focus on that for a little bit. I found my colleagues' comments, Justice Breyer's, quite compelling. It is certainly true that we cannot base our decisions on whether they're popular or not with the people. That's on page 66 of the oral argument transcripts. And so from that, I think there's a chance that Justice Roberts could be interested in upholding precedent for the sake of the court and legitimacy. But, the chance... So there's three liberals who will uphold the precedent and strike down this ban. Justice Roberts could side with the liberals here. And that's a big if, And then there's 5 from these questions, just keeping score, who, it seems like they're sort of announcing on the bench what they're thinking.
To me, the only thing I'm wondering is whether they will write 5 separate opinions
right
upholding the Mississippi law, or whether one of them will sort of take the lead and the others sign on. But I see very distinct points of view here in the 3 new justices, and so I'm anticipating that they each write their own concurring opinion in that result.
So translating what this means, for individuals seeking this care in the future, what do you think people can expect? So let's say our predictions are right and the Supreme Court decides 6-3 to uphold this Mississippi law. What's that going to look like in, the next several months after the decision?
Well, I think what it's going to look like in the next several months, I'm not going to think too long term, because there are options, that might, for example, involve enacting a federal law that would preempt all of these state laws. So if Congress were to do that. But in the shorter term, I know that neighboring states, of the states that are enacting these strict restrictions on the right to choose or on access to abortion, are preparing for people to be traveling and maybe even to be helping with transportation for low-income people who might not even be able to afford the transportation costs to get to another state that doesn't have these restrictions.
So in terms of, it's probably too early to think about hope right now, or maybe it's not. But is there anything, let's say in our minds disaster happens and the justices, overturn 50 years of legal precedent. How long would it take before that decision could get changed?
Maybe not in my lifetime.
Right.
So to wrap up, we realize that this has been a longer session of our podcast, but given that we're talking about the possibility of precedent that's been in place protecting individual rights for these many years, since 1973, we thought it deserved this kind of an in-depth discussion.